The reason we were starting off with that is to try to look at a case study that might get us to look at how international corporations can be governed and re-examine civil and criminal liability of corporations, both domestically and internationally. And then we were going to look at effective forms of new governance. Now, I suspect I'll only be able to get through Bhopal and look at the international, the domestic and really the domestic, civil and criminal liability. So what I'll do is I'll roll over if I don't get there, I'll roll over the new forms of governance for the lecture tomorrow, which is on CSR. So it'll be a neat fit. Let's have a look firstly at the Bhopal case. It's extracted for you in your guides, and it's extracted under this week's readings. It was a fairly recent article that I got, but you should remember that primarily the article deals with the law in the first 4 or 5 pages and then proceeds to continue to discuss what the trust is doing to try to improve the health of the population. But it does deal with the law. So briefly, I'm sure that you're all aware of what happened in that case. But I guess I should ask you, do you remember the facts of the case? Did anyone read the article, I guess I should ask? Which is a bad question, I know. You did? You did? Do you want to start us off on what happened? What are the facts in that particular case study, Bhopal? We all have a vague idea, right? Terrible gas leak, incredible problems, health problems. But what we're trying to get into is the legal setup, the legal framework. Who was liable, who was responsible, which company was set up, how did they try to decrease their liability, what legal strategies did they use? So that's what we're really looking at. So do you want to start us off on what happened, just the facts?
Company said that they don't want, the intention was if the suit is going to be the trial is going to be issued in the US court. The amount of compensation would be more, and so they said that the suit should be issued in the case where the compensation amount should be reduced, and this is a brief and important.
All right. So just to go back to the case, yes. There was the leakage of the pesticide that was being produced. Apparently, the pesticide had to be retained at freezing temperature, but at that, on those occasions when there was a leakage, it wasn't held at freezing temperature, which caused it to be leaked. And it not only leaked to the local areas, but also to waterways, it appears. Although no specific causation was established and the extent of the harm wasn't identified, in retrospect it appears that it did impact on the waterways in the neighbourhood, so it impacted on significant populations who lived around the plant. Okay, so that is the facts, and the company that existed is Union Carbide Corporation. Let's look at its setup. How many shares did Union Carbide Corporation, who held the shares in Union Carbide Corporation in India? Okay, is it in your books? I don't know. Yes, 51, and the government, it was held by the government as well. So 51% was all the shares that was held by the company itself. So, and it was a parent company held those shares. So the question became the liability of this corporation based in India because it's a separate legal entity. As pointed out, the disaster was enormous. There was a lot of confusion about what was going to happen, what people had to do. Immediately after the disaster, of course, litigation is very popular in the United States. Lawyers came down and there was an attempt to try to form some group that could then litigate in the United States. However, and they were trying to go ahead with that process of litigating in the States. However, prior to that, a compromise was reached by the government of India. Does that make sense? And the government decided that the case will actually be heard in the Indian court, as pointed out. And they would waive the rights for the civil action to be heard in the US courts. Now, you made an interesting point of why the company was quite in favor of that.
If the suit has been tried in the US, then the compensation amount would be more than the US, like in terms of the dollars. But if they are going to try the suit in India, then the suit would be, the amount of the compensation would be less. Like the deal would be about $3 billion, but it has been settled about $470 billion.
Okay. So they felt that the compensation would be much less in the Indian courts. So they were able to make that deal, and the particular agreement was signed with the government of India. Now, when that was panning out, the company went into safeguard mode and did a number of things that actually tried to protect itself from litigation. And here are some of the things it did. The first thing it did was to blame employees of the company. Why are they blaming employees? Exactly. So the important thing is when a company makes a decision, for the company to make the decision, remember agency theory again? So if there is a person who is making a decision who has been given the power through the Constitution, then you can argue it's a company's decision. So the question is, how can you decide it's an act of the company? One way you can decide it is to ask whether the person who acted has the powers in the articles or the memorandum. So if they have the powers in the articles and the memorandum, it's clearly an act of the company. So let's say the board of directors has some kind of memorandum that says that they passed a resolution that this particular safeguard of keeping it below freezing does not have to be actually complied with. Does that make sense? If they could, does that make sense? So if they could see that the board of directors actually provided or were involved in allowing the leakage, then the board of directors is supposed to be the brain of the company, making all the decisions. So if they passed a resolution, you could say it's an act of the company. Right? If that, remember, is actual authority, that it's actually provided for by the articles or memorandum. The other way you could argue it is, you could say there's a director of the company who has the power, or a managing director who has the power to act on behalf of the company by the articles or memorandum, or just usually. So if it's a CEO, the idea is a CEO actually runs the company, or a managing director runs the company, then the company would be liable. It would be an act of the company. But you can ask the question, what about other officers? other employees. In this case, they tried to blame an employee, and they tried to say the employee actually sabotaged this, and they were really angry, and they tried to make sure all the gas leaked out. If the employee is the person who has committed an act, how can you say the company is liable? What process would you put in place to try to argue that?
The employees act under the duty which if the employee has a duty to take care of that, like what the duty has been imposed on him, and he has breached that duty, and he gets that by the vicarious liability when the company is going.
Okay, so you can argue that it is vicarious liability or primary liability, but vicarious liability is only going to work if you can argue it's within that person's actual duties. So the question here is whether sabotaging was within his duties.
Actually, they done absolute liability. So they went beyond the limits of vicarious liability and laid down absolute liability, where the onus is upon the company which is engaged in an activity like this. Take care that something like this doesn't happen. They can't push this liability off on to one of the
Right.
They don't have any defense regarding the himself, because the strict liability earlier what the concept is regarding this type of act is the strict liability, where you have the prosecution and the defense, but in absolute liability he doesn't have any defense.
Mm-hmm. So you're arguing this case is one of absolute liability? On what basis?
based on the activity they're engaged in.
And who held that? In which case?
It was laid down in this case.
It was laid down in the
What was testified?
The concept is laid down.
Oleo gas is after this.
Yeah, so it was laid down later on the
But the
consequences of
composition
absolute
is
liability.
Absolute liability was
absolute liability.
And only classic liability.
it was laid down in this case.
Yes. I'm pretty much sure.
So what does absolute liability mean?
Where you cannot take any defense, like in the strict liability, you can take a defense of health awards, but in the absolute liability, you cannot take any defense.
Whether the nature of the industry itself is so hazardous that no lapse on the part of the company or no lapse resulting from anything else also can compensate for it. It cannot be an excuse. It's absolutely.
Like even if you have handled that industry with a very clear and reasonable care also, then also you cannot take the method. Even we have taken the even we have managed that industry the due care and reasonable care. So the liability should not be imposed.
And they own a certain duty of care, and this tender is you manufacture it needs to be cool on certain temperature. And on one way it was said that somehow say switched off the connection, and in order to make that in order to save electricity, when you switch off the light and the cooler was switched off accidentally or intentionally or knowingly or unknowingly, so the temperature of the methyl hydrocyanide increased and it led to the leakage.
All right.
This is something they own the duty of care towards this chemical, and then it makes them liable absolutely for their.
Okay. All right. So if we can just come back to the act of the company itself. The company can be liable if it's vicarious liability or vicarious authority or actual authority. In this case, that idea of strict liability or absolute liability might fit just for the company itself. Okay. That doesn't really look at the Employees Act. Does that make sense? The employees are only liable if it's within their vicarious or actual authority. Does that make sense? So what I'm trying to ask is, how can the company be bound? The company can be bound by diverse means for an act. It can be bound by the act of the employees only in this instance. It can be bound if you want to argue absolute and strict liability because you're arguing its special circumstances. And it isn't necessarily applicable here. All right. So in this case, what happened? Well, I'll just come back to that. In India, the proceedings started in the Supreme Court in Bhopal, and it was decided that the jurisdiction was going to be in India, not in the New York courts where the proceedings started. And the New York court agreed that the place where the action should take place is Bhopal in India. The important thing here was that the government decided to represent the citizens. And as you have said, the governments decided, sorry? Okay. Anything else? Let's just talk about it before we go through that diagram. All right, so it was a class action that was brought, okay. Where? Where else? Yep. Class action in India and in the States. Yep, that's right. What other kinds of action was brought? Criminal action was brought. Against which party? And what happened to him? He's dead.
Earlier he was abscond, now he's dead.
Yeah.
Abscond, he's in the list of absconders.
Okay, but he's gone now, somewhere else, having a happy time. So, okay, so criminal action was brought. Criminal action was brought against an individual, not the company. Civil action was brought against the company. Okay, all right, great. Now, what did the company do? What did the company do? What did Bhopal do? Sorry, what did Union Carbide do? Did they pay up and open themselves to liability? Did they hand over Anderson? Did they say, yes, the parent company should be liable as well? What did they do? All right, so some of those lists are there, the things they did. The first thing they did is they said the Indian subsidiary is a separate legal entity. So it's not liable. The parent company in the United States isn't liable. That's the argument they ran all the way through. They pulled their chairman out of India and hit him. That's the Warren Anderson. The other thing they did is they divested themselves of a whole lot of products that was dangerous. So, you know, Glad wrap and batteries, few other pesticides, they sold them off. So they made the company actually sell it off. And the other thing they did is they took on debts of $6 billion. So they actually, from their related companies, they took on debts, which meant that the company was so debted that if anyone sued them, there was no assets to pay. Does that make sense? Okay. And then the other thing they did in 2001 is they sold all their shares to a new company. So Union Carbide actually ceased to exist. And the new company was Dow. Is that okay?
There was no injunction.
No?
No injunction given against trading company shares. There was no injunction given by court that during the period of litigation, the company cannot sell its shares or engage in any form of trade.
Oh, right. The parent company is the one that sold its business, not the subsidiary company in India. The subsidiary company in India, its shares were taken by the government and they were sold, and that money was used to build that hospital. So what happened in the meantime is this, I've just tried to divide it up into civil and criminal, inside India and outside India. The thing to remember is that there were a number of actions. So the first set of actions came in, I think it was 1989. So, or actually 1980, maybe even earlier. Maybe 87. So these actions here, and the Supreme Court settlement was 1987 of 470 million. Then there was a review because the Gandhi government went out of power. And the new government that came in wanted to re-examine the case. So there was a review of this case, and it went back to the Supreme Court. And that was a case in 1989. And there was also action filed for civil liability against the subsidiary company, the parent company, Union Carbide, that owned Union Carbide in India. And that was filed in the US. 3 cases were filed in the US that have just finished being heard, and they're still on appeal. But they've gone on appeal. The civil action also continued outside, and now the civil action is against Dow, which is the company that took over Union Carbide. And there's also attempts by shareholders to try to list the potential liability that might arise for Dow in the meetings and in the annual reports. So civil litigation has been continuing over some time, but it hasn't really offered any remedy to the people. So let's just proceed and firstly ask the question, was it a wise idea to choose India as the place to bring the action? And if so, why? Or in retrospect, should it have been done in the United States? I suppose one has to think about having one action, all the class represented, somebody overseeing it, reducing the rent seeking that often comes with class actions and lawyers who will often take big fees. Also, the government could then use the funds to try to distribute it to relevant people. So I suppose one could say there were reasonable grounds. Actually, the person who played a very important part in this case when she was in another place is Amita. She was actually working at that time to collect information from all the potential victims, the potential members of the class, to try to document the kind of injuries they'd suffered. And that documentation has been published. However, during that documentation, the agreement was determined by the Indian government with the company to take on that particular settlement of 470 million. As you correctly pointed out, there was a huge shortfall because, as you said, they estimate it would have been many, many billion if the action had been brought elsewhere. Now, the action to take a criminal case, however, in 1989, they said, yeah, go ahead and take the criminal case. So the criminal proceedings were brought against Indian executives. And did they succeed? I suppose. They succeeded, apparently. And the Indian executives were actually sent to jail, although they have appealed. And in 1991, there was the confiscation of the shares of Union Carbide in India, and they were sold following this particular decision. And now they're asking for Dow to be responsible. If you look up the Amnesty International website, you'll find quite a lot of information about why they feel Dow should be responsible. And Dow is now taking out restraining orders against the activists to stop them from affecting their share price. So, I guess the question is it fair? What else should have happened? If law is not the answer, what else can give an answer? All right. Perhaps I can talk about the way in which different NGOs have attempted to access others, not just the courts, because accessing the courts has failed. So they've tried to access the shareholders of Dow. They've tried to get resolutions onto the general meeting of Dow to consider the potential loss that could flow out if Dow was held liable. But the directors have refused to include it, and it's been held that that's a reasonable response not to include it. It's gone to court, and the court has said, yes, there is no real danger of that particular environmental or social damage actually affecting Dow's profitability, and therefore there's no need for the directors to disclose this information. So, any questions? I guess then, okay. I guess then the thing is, where to next? So the conduct that the law did not regulate was that they didn't lift the corporate veil, they didn't hold the parent company liable, they didn't hold now Dow liable. The environmental damage that's been caused is not actually compensatable because it's supposed to be some sort of externality. It isn't necessarily linked with what the corporation did, and they signed off saying they won't be able to bring any further action. The Supreme Court in 1989 agreed that the previous decision of 1987 was a valid decision, and the settlement entered into by the government of India was binding. However, they could bring criminal action if they so wished, because the government of India had not made the settlement order. Although they'd waived the rights to bring civil action, they hadn't waived the rights to bring criminal action. Therefore, it was agreed that perhaps criminal action could be brought. So the next question is, can you hold the guilty party liable? Is a company liable or an officer liable? They tried to bring the officer back in line with the extradition treaties, but the United States courts refused to honour it and refused to provide that the Warren Anderson can come back to India. And the appeal process took such a long time that he actually is never going to come back to India. And finally, the government didn't really take on board the actual loss, which again is a problem with environmental disasters. When there is an environmental disaster committed by a company, how do you actually estimate the loss? Because it's something that gradually becomes obvious, such as the BP disasters. And how do you try to make sure you calculate that within your damages? They're all problems that have not been addressed by this decision. The way in which Bhopal was able to avoid liability was because of the parent-subsidiary relationship. The parent company was able to then sell off assets, was able to keep Bhopal keep Union Carbide in India with very limited assets, and they were able to strip all the assets from the subsidiary company, leave it with a huge debt, and sell off to the parent company, and then the parent company eventually sold it to another public company. So the ability to divest yourself of your assets and also change your corporate form, stop living, wind up the company, sell it to someone else, it becomes a new entity. The liability of one company can't be passed on to a new company, is an interesting thing that happened in this case and happens constantly. Selling off profitable or dangerous parts of the company to someone else is another way of avoiding liability where there's a company group, and that's another thing that happened. And taking on big debts before litigation is the third thing that they did. So all of these things are only really able to happen if there's a corporate group, if there's a group of companies that are able to help each other. I can ask you, what is the meaning of a corporate group? What do you understand by corporate group? Okay, I suppose a corporate group can be a formal one or an informal one. If it's an informal one, it might be one that exists in one space that might assist each other, but there's no real contracts between them. And that is often an accusation made of banks, made of pharmaceutical companies, that they all assist each other and they all work in a way to promote each other. Airlines. However, it can also be formal, and where it's formal, it's interlinked shareholding. How is that kind of, how does that happen? Well, let's just look at the risk of drawing something on the board, which I shall take it on. Yeah.
Are they allowed to do this?
Allowed to do what?
Get in tandem with each other, different companies, and helping each other out, and dealing with the other companies in situations like this where they ought to be held responsible and pay that. It's not legally allowed.
So give me an example of that, because you know it can happen in so many ways. Some are legal, some are illegal.
I think in 2012 there was a controversy around many cement companies that they were cartelization. They were fixing prices, or they were consulting each other to fix the price of the cement so that they all earn a certain amount of profit no matter how the company performs. So in that case, I think it should be held invalid. But in these kind of cases, it's very subtle and like you can't specifically point out, right?
Yeah.
So depends on the.
So we have competition law and we have corporate law. Competition law regulates competitive activities, and the aim is to create a competitive market. The main provisions it tries to regulate is cartels or collusion. Collusion can occur vertically or it can occur horizontally. Collusion that's normally done by companies in a particular industry like airlines or like cement is usually horizontally. It can also occur vertically, such as a number of banks saying that what we will do is we'll only, or number of cement companies, will only supply cement to people who will sell it at a particular price. So that is a vertical agreement because companies who are supplying have reached an agreement that they'll only supply at a particular price to retailers or wholesalers. Another vertical agreement could be where the companies at the top decide that they will divide areas geographically. So one airline company will say, don't worry, we can compete, but I will keep the Asian to Singapore market, the India to Singapore market, and you can do the India to Bangkok market. That's a geographical division, and it's an agreement, which can also occur horizontally or vertically. Those kinds of agreements are regulated. But the important thing about those agreements is firstly trying to convince the judiciary about the actual value of competition policy and the fact that having a competitive market is good for the economy. And to get them to understand basic market principles and looking at price differentials. Judiciary always look at conduct that can equate to an intention. And the judiciary will always want memorandum, meetings that happened, meetings in one place that happened, that they can then decide is equating to the collusion or collusive conduct. In certain instances, in big cases, they're able to get that because there are associations involved. But a lot of the conduct never really gets discovered. The Indian Act is new, and I understand there have been 3 or 4 cartel conducts that's been regulated. Whether or not it will continue to be regulated and whether or not they can detect enough of this conduct remains questionable. So in answer to your question, competition law regulates competition within the market, market size, market conduct, market structure. Corporation law is not related to that at all. Competition law regulates corporations, but corporations are related to something completely different. What the corporations are doing is dealing with the way in which they can facilitate economic growth, investment within the corporation, and how the company can engage in entrepreneurial activity and still be responsive to its stakeholders. Competition law, on the other hand, is looking at the marketplace and saying, unless we make it a fair marketplace where companies can function, we won't have the ability for entrepreneurship, and we will end up with a monopoly. Slightly different rationale. They link in a couple of areas. One of the ways they link is if the directors of a company are actually engaging in this kind of collusive conduct, and you can prove it, you can show breach of directors' duties, and the director can be held liable. It's very difficult to hold the companies liable for criminal conduct just because they enter into cartel agreements. It might be possible, but that will depend on the facts. So does that tell you the overlap of competition and corporate law?
Just one small doubt. The criminal liability, if it's imposed, will it be individual or on the corporation?
Okay. So, yep.
In the case that he mentioned, the cement cartel case, each company was held liable, and also there was so basically this was illegal, whereas there was a legal organization, even that was fine. So individual company as well as them together will be fine.
Cartelization itself per se is a wrong, illegal.
So to come...
Something is that the corporation among itself make the agreement among themselves not to keep the bid high, low, ma'am. So it is indirectly putting the option, ma'am, so itself per se is wrong.
The question that's being asked is it's criminal liability or is it civil liability? Not what it is. So the question is, if someone is engaged in a cartel conduct, is it civil or criminal liability is the question. Okay, so the answer to that question really depends on your legislation. This kind of conduct isn't regulated by common law. Your legislation will dictate it. Generally speaking, from what I know, it's a fine under the competition law. The corporate law, however, goes slightly differently. The corporate law is embracing both, it's embracing a hybrid. The Companies Act is a hybrid. It is trying to say you pay a fine or you go to or you get imprisoned. So it's mixing up the notion of criminal and civil. It's attaching both. Not to the company, but to directors. All right. So to come back to the question I asked earlier, interrelated companies can occur in many ways, and they can occur for many reasons. So let us say that there is a company called X. Let's say that it is actually dealing with cement production. However, the company called X also wants to set up supplying of cement, wants to establish a fleet of trucks that can then take cement what it might do for that reason is set up a subsidiary company, X1. That way, all the trucks owned by the company belong to that company, and the liability that happens to that company is restricted within that company. So if one of these trucks, for example, doesn't do the pouring in a proper way, and a whole development is built in a negligent manner, the liability stays only with X1, not with X. The same employees of X and X1, they might be common, but it stays with X1. Let's say then it wants to get into another action, another activity which involves some sort of diversification, not just related to cement, but something else, like property development. If it does that, it can set up X2. It can be 100% shareholder in each of these. Let's say it's set up X2 and it's a property development, but what it now wants to do is it wants to sell that property to people. So it doesn't actually want to engage in it itself because it knows it might be liability. For example, defects when you've developed a property only come up after 3 years. It doesn't really want to be there when that defect happens. So what it will do is it will set up X3. X3 might be a 50% partnership with X2, and it might be a 50% partnership with company A, which is a real estate agent. That real estate agent and this company then set up X3, so all the apartments that have been developed by this company is then sold to X3 at perhaps a very high price, whatever they think they want to do, and then this company can then market it to individuals. So let's say defects are then picked up 3 years later. The action will be against this company. Unless there is some statutory warranty that says the directors of that company have to be around for 3 years, this company can actually fold after it has made all its sales. If it folds, these guys are left in the lurch because it's a separate legal entity. That's similar. So what is the rationale? The rationale for related companies can be, firstly, diversification. Secondly, it could be vertical and horizontal integration of production. Thirdly, and most importantly, it is trying to actually get rid of risk. It's trying to reduce risk by forming another company. Now, all these companies might just be a 10 lakh company. But the risk that's happening here could be in the millions. So all you can get access to is the 10 lakhs. Right? So the important thing is it's not just setting up companies that's relevant. Here you have the same shareholders. But sometimes what can happen is the same directors can also be in each company. So Director 1 and Director 2, Director 1, Director 1, and then Director 3, Director 3. When you have a group like that, what they're really doing is actually acting in an interrelated manner. Does that make sense? They know that if one company sinks, another company is likely to sink. So rather than necessarily acting in the interests of that company, they're acting in the interests of the group. And often, what they can also do is hide risky events. Let's say that this company is being sued by all these apartment holders. What this company can do now is it can try to reduce its assets.